Hi, I'm Dr. Stacia Dearman, the founder of Thrive, where I provide educational resources and support to physicians facing unexpected patient outcomes and malpractice litigation. Today, I want to talk with you a little bit about testifying at deposition. Tip number 1, follow your lawyer's lead. In the course of my own malpractice litigation, it became apparent to me that I suffered from what I will call a followership deficit. It's a little embarrassing to me to admit that to all of you, but it's true, and I suspect I'm not alone. I think it stemmed from the fact that in my professional setting, in the context of clinical practice, when the chips were down for my patient, I was expected to take the reins, to take the lead. Well, now here I was in a situation where I was in my professional context and the chips were down this time for me, and I didn't really know how to take the lead. Well, I've got good news for you. There is someone who can take those reins for you, and that someone is your defense attorney. That's their purpose, to be there to guide you through this lawsuit in the best, highest integrity, most effective manner. Deposition is a crucial juncture for many physician defendants. In fact, some defense attorneys like to say that many cases are won or lost at deposition. So you want to go in well prepared. And one of the most important jobs your defense attorney is there to do is to prepare you. They're going to attempt to anticipate the kinds of questions that the personal injury attorney may ask you and to rehearse those questions with you, allowing you to formulate your answers in a way that is consistent with the truth. Above all, you need to be truthful because you're testifying under oath, but is also concise and open to little or no misinterpretation. That is very important. They may want to spend hours preparing you, depending upon the complexity of your case. And I would suggest that you take them up on that. Invest your energy in depo prep. And if they come to a place where they think you're ready and you still feel like you're not, ask them for more. It's one of the most important things they're there to do, prepare you for your deposition. They will, of course, be best equipped to prepare you if they know everything there is to know about your case. There are some things that are not captured in the medical record, right? Features of the interaction that you had with a patient may be an example. I encourage you to share all of that with your attorney in full. That will permit them to guide you in the best possible way. And last of all, I want you to let your attorney tell you what to review before deposition. I do not recommend that you go off on random PubMed searches or reading the medical literature to brush up prior to your deposition. It is almost certain that you will be asked at the time of the deposition what you reviewed in preparation, and any materials you reviewed may at some point be used against you. So turn to your attorney for guidance here. Some will simply recommend that you review the medical record, and in that case, you will want to review the same copy the court is using. So let your attorney provide the copy they want you to look at, review it thoroughly, and know it back to front prior to your deposition. Tip number 2, be truthful. I cannot overstate this point. It is imperative that you're truthful at your own deposition. At deposition, you'll be under oath just as if you were in a courtroom. And in fact, a deposition is viewed as an extension of the courtroom. It allows the court to conduct its business without consuming the full resources of the courtroom environment. Your testimony will result in a transcript, and that transcript will become part of the legal record. As of now, you've been accused of a breach of contract, which is not a crime. Perjury, on the other hand, it's a felony, and your medical malpractice coverage is not designed to provide defense for you in the event of criminal charges. So you want to be very careful in the context of your deposition to stick to the truth. There are other reasons to stick to the truth as well. First of all, nothing is a greater gift to the plaintiff's attorney than for you to be caught in a lie at your deposition. Why is that? It's because jurors who are members of the lay public rightly expect truthfulness and integrity from physicians. So no matter how ugly the truth may be, it is your best defense. It's important that you tell the truth for you. I want to forewarn you, plaintiffs' attorneys sometimes engage in tactics at deposition which are distasteful or even sometimes feel mean or disruptive. Those tactics can sometimes inspire fear in physicians, and sometimes fear tempts us to do things we wouldn't do on any other day. It's important that you go into deposition committed, no matter what, to sticking to the truth. At the end of the day, I think you'll feel better about yourself if you leave your deposition knowing that you entered it and left it with your integrity intact. Tip number 3, slow down. This one is actually much harder than it looks. Typically in the context of deposition, a physician's adrenaline is pumping, and in that hyperadrenalized state, it's easy to rush to answer questions before they've even been completely asked, to answer a different question than the person was going to ask you, or to stumble over your words or make mistakes in your answers. So what I want to encourage you to do is to just pause. Let the plaintiff's attorney ask their entire question. Take a deep breath before beginning to answer. Use that time to formulate your answer so that you answer in a manner that is both succinct and truthful. If they've asked you a question that feels to you like it may be open to multiple interpretations or is overly complex, ask them to rephrase it and as many times as you need to until you have a question you can answer concisely and truthfully. Now, you may find that a plaintiff's attorney engages in strategies designed to speed you up. I promise you, there is no advantage to you in speeding up. They are trying to rush you, to make you trip over your words or speak without thinking. Your job is to pause and think first. At the end of the day, you are the only person in that deposition who's under oath. And I promise you, should your case be among that small 10% that go to trial, bad answers may be read aloud in a courtroom. Bad questions they've asked, they're not going to bring those up. So take your time. It's to your advantage. Tip number 4, be brief. In his book, How to Answer Questions at Your Deposition, lawyer David Grappo emphasizes this point. Once you have understood the question that you are being asked fully, answer only that question. If it's a yes or no question, yes or no is a perfectly adequate answer as long as it's truthful. If neither yes nor no is quite the right answer, then indicate that and wait for a question that you can answer truthfully and succinctly. In the context of deposition, it is the plaintiff's attorney's work to come up with the right questions to ask, and it is your job to answer those questions truthfully. If you find that they can't seem to find the right question or they're not asking for the details you'd like to give, I would encourage you to let it go. Answer the questions you're asked and only the questions you're asked. You may also find, particularly if a plaintiff's attorney hasn't really done their homework, that they repeat a question over and over in the hopes that you will elaborate or volunteer additional information. You are not there to educate or persuade them. If you feel that you have answered their question completely, you can either repeat the answer you gave verbatim or indicate that you've answered the question fully and wait for a new question. It will always serve you. As long as you answer the questions truthfully, it will serve you to be brief. Tip number 5, do not speculate. Attorneys who work in the world of medical malpractice on either side are likely to surprise you with how much knowledge of medicine they've accumulated over time just in the course of their careers. This is not the same as going to medical school, however. You may find in the context of your deposition that the plaintiff's attorney asks questions which invite speculation from you. They may, in fact, be hoping that you will provide them with a theory as to what happened to their client that will win their case for them. You are not there to provide that speculation. In fact, you took an oath to tell the truth, the whole truth, and nothing but the truth. In my view, when we delve into speculation in the context of deposition, we're violating the boundary created by those words, nothing but the truth. If the plaintiff's attorney asks you a very open-ended question, such as, what do you think happened? It is appropriate for you to say, I don't know, if in fact that's truthful. You need not speculate. Attorneys on both sides, plaintiffs and defense, are hoping to learn things at your deposition that will enable them to win their particular client's case. You, however, are not a neutral party. You're not on both sides. You are the defendant. While you may choose to discuss theories with your defense lawyer, in the context of your deposition, I want you to remain absolutely bound to the truth. All right, that's it for now. I'm Dr. Stacia Dearman, the founder of Thrive, and you can find more information about the online course I've created for physicians navigating a medical malpractice lawsuit, as well as information about the coaching work I do one-on-one with physicians and other healers recovering after an adverse outcome or confronting medical malpractice litigation at my website, www.thrivephysician.com.